With that, I'm going to call our first case for oral submission this morning, PD-0284-25, Bobby Carl Lennox, also known as Bobby Carl Lennox, of Leanox versus the state of Texas. I believe we'll hear first from counsel for the state. As counsel approaches, if they could speak clearly into the microphone and remind us of their name and who they represent, I'd appreciate it.
May it please the court. Counsel, Mr. Hornsby. My name is Jeff Shell. I am here once again as a special prosecutor, this time for Lamar County, Texas, and its recently appointed County and Criminal District Attorney, Nick Stallings. If there's one salient point I'd like to make this morning, it is this, that the state acknowledges that the value ladder in subsection E1 of the forgery statute is an element of the offense, as this court's previously said in 2024 in Green and Lennox versus the state of Texas. This is 682 Southwest 3rd at 253. Former Judge Michelle Slaughter wrote an 8-0 opinion with Judge Erie concurring, and in that opinion the court essentially said that subsection E1, which the legislature in 2017 added to the forgery statute, was an element of the offense. It is not, as I argued in 2020, by Zoom during the height of COVID, that E1 was meant as a punishment issue. The court clearly did not adopt that statutory construction and instead said it was an element of the offense. So if it is an element of the offense, when is it supposed to be raised? And in this case, which is now before the court again, this is its second time to come up through the appellate ranks. When is 3221 the value ladder? And I'm going to refer to 3221 and the value ladder synonymously throughout this argument. It means the same thing. If I interpose the two, I apologize. But for all practical purposes, E1 is what is at issue. And when is E1 supposed to be raised? In this case, if the court looks at the indictments, and the indictments are set forth in the clerk's record, pages 6 through 7. And by the way, this indictment is file stamped February 14th, 2019. These cases were indicted in February of 2019, and this indictment does not incorporate subsection E1. It went to trial under 3221 subsection D, which at that time, D said it was a state jail felony to forge any writing that included a commercial instrument, a check, a will, a codicil. They're all listed in subsection D. At no time during the trial or the pretrial proceedings of this case did Mr. Lennox ever raise subsection E1 as an element that was defective and left out of this indictment, nor was E1 ever raised at a jury trial conference, at a pretrial conference, in a motion to quash this indictment. At no time was it raised. So for the Court of Appeals now twice in Texarkana to send this case back for a new trial on punishment without even E1 ever being raised is contrary to Marin. It's contrary to everything that I have ever learned about preservation of error and under Rule 33.1A.
So I have several important questions, right?
Of course.
Yes. First of all, the trial judge has a duty to instruct the jury on law applicable to the case.
Yes, 3614.
And you're saying that subsection E1,
Yes.
you've said it a couple times, you've said that it's an element of the offense.
Yes, now we know that.
So if it's an element of the offense, then it seems to me that it looks an awful lot like law applicable to the case. But if you view it as an element of an offense, maybe one distinct from the one that was being tried at the time, then it might not be law applicable to the case unless the defense brings it up somehow.
Correct.
So that would say, if you're making that argument, that I'm trying to understand it, because I keep hearing you say the offense, and maybe it's because Lennox said something like that. Maybe that's leading you down that path. But again, that was COVID, so who knows?
Lead me
who knows
however
whether we
you
made
want
mistakes.
me to be led.
So anyway, that seems to me to be one of the most, if not the most important question. Is this a instruction on, is E1 law applicable to the case, or is it something that otherwise should be in the realm of the defense to ask for it to be law applicable to the case, as if they would with a lesser included offense instruction? Because we know that defendants don't have to ask for a lesser included offense instruction, and
True.
if they don't, it doesn't become law applicable to the case.
True, and the trial judge on his own could incorporate a lesser included offense.
Right.
That's absolutely correct.
Okay.
But the law is also clear that the trial court has no duty to sua sponte submit a defensive issue, like an E1.
And there's the crux. Is
Yes.
this a defensive issue?
Yes.
Or is it an element of the offense?
Okay, let me clarify this. This court's prior opinion in Green and Lennox said that it was a element of the offense. Okay? So there's two prongs to the state's argument here. The first prong is that if it's an element of the offense, it was left out of this indictment and it was never quashed. That's prong number one. Prong number two is that E1 is also a defensive issue that might reduce a otherwise state jail felony offense to potentially a Class B misdemeanor based on the amount of the forged checks. And so if it's a defensive issue, then the trial court has no sua sponte duty to incorporate a defensive issue that Mr. Lennox never asked for. So either one of these two prongs, the state's right and we win. So that's the two-prong argument that I want to present to the court to answer your question. If it's an element of the offense, it's a defective indictment, and a defect in an indictment has to be raised pre-trial in a motion to quash under Studer, under Teal, under 1.15B of the Code of Criminal Procedure. That was never done here. And it's the state's argument that that has not been preserved. And because it's not been preserved, it went to trial under 3221 subsection D as a state jail forgery of a financial instrument.
Well, I'd say that troubles me, because there have been a couple of cases over the last couple of years where it seems the court has, in my view, right, mixed metaphors, right, where the court has said that, no, this isn't a jury charge problem, it's a sentencing problem. Or this isn't a jury charge problem, it's an indictment problem. And that, you know, when the party raising the question is raising a jury charge question. So it seems to me when the question is a jury charge question, shouldn't we treat it like a jury charge question and answer that question? I don't see this, I don't know that is one of the grounds of review that we granted whether the indictment was sufficient? Did we grant a ground of review like that? Because I don't remember that being one of the grounds that we granted.
Well, what the court granted two grounds. Number one was that the Court of Appeals never addressed the preservation issues on remand. It specifically did not follow the directive that this court said in Green and in Lennox, which is, by the way, on page 10 of our brief. We've set forth what this court said in Green. Quote, "We expressly do not decide at this juncture whether and under what circumstances a defendant may raise such a claim pre-trial based on the facts alleged in the indictment, as opposed to only being able to raise such a claim after the facts have been adduced at trial. We similarly do not decide at this time what preservation requirements would apply to such a claim that the defendant is being prosecuted under the wrong statutory subsection," close quote. That's what this court said at page 278 of the opinion. Now, having said that, we drafted our ground of error in a manner that simply asked, on remand, did the Court of Appeals correctly decide whether and under what circumstances any defendant, thus the big picture, any defendant, including the appellant Lennox, might raise a claim that he was being prosecuted under the wrong statutory subsection, i.e. E1. As this court directed in Green, or upon de novo review was error not preserved on this important question of law. That's the ground the court granted on, and that's what I'm trying to say. This is not preserved. E1 is not here.
But that's premised on two default positions you're taking that are different from each other by definition, right? One is
Yes.
that the value ladder was not included anywhere on the face of the indictment,
Yes, sir.
right? But does
Correct.
the indictment, to be sufficient for these purposes, need to cite to subsections and paragraphs, right? I mean,
Right.
the indictment did include the amounts of the checks.
Yes.
Right?
Yes.
So how is it not present in the indictment?
Well, it didn't track E1.
Does it need to track it? Does it have to go E1, E2, E3? I mean, if that were true and there were a Scrivener's error in an indictment that had the wrong paragraph, it said C instead of B,
Yes.
would we have a deficient indictment?
No, because it's not, that's a form defect. That's,
Okay, but why isn't, you included, I think there were copies of the checks.
Yes,
Okay,
yes.
so what's missing? I mean, it's facts, the point of the indictment is to give due process notice to the defendant of what it
Yes.
is he's accused of.
Yes.
That's factual, right?
Yes.
Doesn't need to say, it needs to say against the peace and dignity of the state, if I remember correctly, but it doesn't have to say subparagraph E1-2-3, does it?
No, it does not.
Okay.
But it does have to state something that says what E1 is specifically designed to invoke, which is that it was for goods or services, that could include money. It could have done any number of different things, but it doesn't say that.
Why would the legislature write a law like this? I mean, it's so odd. I mean, normally, you're arguing it's a defensive issue, right?
Yes.
Okay, so normally when the legislature writes a defensive issue, they create it as a defense, and they'll say it's a defense, or they'll put it in an area of the code that where there's other defenses. It's very unusual for them to write a law like this. I think we've said that a couple times, but is it the case that there are no circumstances where someone can commit a forgery without doing so in order to obtain property or services? Or are there circumstances when someone can that are different, so that the legislature might be saying there's a public interest in treating these people more leniently at stake?
Okay. I'm not here to question our legislature. Let me say that first of all. Could they have written it better? Perhaps. Are there factual scenarios where you can forge a certain document and the consequences not be under E1? Yes. But for specific purposes of this very case, we're talking about a financial instrument that was clearly subject to E1 and the value ladder, and it was simply never raised. Not at trial, not at the jury charge conference, not at any time during Mr. Lennox's trial did this ever come up. So to now come back and say, well, it wasn't preserved. It simply wasn't. And you can't unring that bell. I see I'm out of time, unless I'm happy to continue to address your disagreements with the legislature, or even my disagreements with the legislature. The legislature could fix subsection E1, but I don't want to argue this again like I did in 2020 ineffectively.
Well, I don't know about that. It's hard to lose the same issue twice if you're on the opposite sides of it both times.
Exactly. Exactly.
We'll find out. But okay, you've got 5 minutes, I think, reserved for rebuttal.
Thank you.
Thank you.
May it please the court. Mr. Shell, I'm Troy Hornsby. I'm an attorney in Texarkana. I've been representing Mr. Lennox from the beginning, about 6 years ago. Based upon the law applicable to this case as laid out by this court and the particular facts of this case, I don't feel the Court of Appeals had any reasonable choice other than what they did. And let me explain what I mean by that. Let me address first the indictment issue. I believe that the indictment, and I've maintained from the beginning, that indictment does allege E1. It does allege the value ladder. Why? This court said, what makes the E1 section, the value ladder, different than the D section? Two elements: the amount, and that it was for the for property or services, I believe. Property or services. Those are the two elements. Okay, do we have those two elements here? We do. Not in the wording of the indictment. If we looked at the indictment, I admit, follows D perfectly. But the state put little images of the three checks in the indictment. So what do we know from looking at those three images? We know there were three checks. We know that the amounts were $130, $137, and $150. Exactly. Well, check that. We know the value amounts, they're in the indictment. Well, was it for property? It was. How do we know? The check is written to Bobby Lennox, my client. It's for cash. Cash qualifies as property. We know that statutorily, right? So the two elements that this court said, you got to meet these elements. If you meet these elements, you now have E1. They're in the indictment. They're in the indictment. So, although, and now you could say, well, but the indictment follows D, and then you have this extra information. True. They're both in there, D and E1. So you go, all right, well, wait, now you've got both in there. What do we do now? Well, we know the statute says that E1 is subject to the value ladder. This court said that it controls. Okay, we got D1 and we've got D and we've got E1, both in the indictment. We know E1 controls. The indictment alleges E1. Move on.
Let me ask you this, though. The statute says that it depends on the facts at trial ultimately showing.
It does, yes.
So why would it have to be in the indictment?
I don't think that it does. No, I don't think that it does. Absolutely not. In fact, this court made that implication in when it wrote about this, that in fact you could allege a Section D violation in the indictment. You go on to trial and, hey, wait, this looks more like E1 based upon facts. I absolutely agree. You're absolutely correct. So no, I don't think it is. I'm just saying if the challenge is, hey, you should have objected to the indictment, I'm just trying to throw that argument out. I'm saying, wait, we don't have to object to the indictment. There's nothing wrong with the indictment.
But there I guess I'm just thinking there wouldn't have been anything wrong with the indictment even if it hadn't had
I completely agree with you.
under
I-
E1.
I completely agree with you. Yes, ma'am. So now we've got to move on to the second thing. All right, well, what do we have here? What is this? Okay. The structure of these charge errors has been addressed by this court for years. We've got a little subsection estoppel. What's estoppel? Well, if I, as the defendant, request an instruction, well, now I can't come back later and start complaining about it. Well, we didn't Mr. Lennox didn't request an instruction, so estoppel is right out. Forget estoppel. It's not an issue here. Okay. And we're going to get to the Almanza part here in a minute. But what does that leave us with? That leaves us with what I call optional or defensive issues. That's where we need to look, right? Is this a defensive issue?
Let me ask you a quick question.
Yes, sir.
Does it make any difference at all that the indictment literally says it's state jail felon? I mean, that's what it describes it as. Does that make any difference?
No, I don't think so because it's alleging both, Your Honor. I think it's alleging both.
So there's no duty to clarify, to object, to point that out?
No, Your Honor, you might have an indictment which charges murder and later, you're looking at lesser included issues, right? I mean, so you say, well, hey, it's alleged murder. You can't have manslaughter. Well, sure you can. Sure you can, right? It's a lesser included. This isn't lesser included. I'm not saying that. But
Right, this isn't a lesser
It
included.
is not, and I'm going to address that.
Okay.
Yes, sir. I'm going to address that. So under optional, I put lesser included instructions. What you're raising there, Your Honor. Defensive instructions, affirmative defenses, these sort of things. These are defensive issues. This court addressed that in Posey v. State. What is a defensive issue? It's something that has a strategic decision. Maybe you want it, maybe you don't. It's optional, right? It is, quote, under Chase v. State, discretionary. Maybe it's in there, maybe it's not. It is not the law applicable to the case, as you were saying. It is not the law applicable to the case. Ergo, it is a forfeitable right. And that makes sense when we understand all those things, right? Hey, well, maybe it has to be in there, maybe it should be in there, maybe it's not. It's not mandatory. You can waive it. And in this court addressed that more particularly in Taylor v. State in 2011. It talked about these things. Does the statute call it a defense? No. Is it a strategic decision? Is it discretionary? Or is it the law applicable to the case? All right. So we've got a framework to work in. So now let's try to apply that here. Here, it is not a defense. How do we know? You said so. You said it's not a defense. You said it's one of 4 offenses. They're under there. You say there's 4 offenses under there. It's a special deal. Why? Why would I say it's special? Because we clearly, the statute says that D1 is subject to, and it controls. Okay, so what is that? I think it starts to smell like lesser included, but something more, something bigger, something stronger. Why? Well, because lesser included is discretionary, right? But this isn't discretionary. The legislature said so, you said so. It controls. That sounds like law of the case to me. Law applicable to the case. I'm sorry to say that. Law applicable to the case.
Can you help me understand something?
Yes, sir.
Because we're supposed to read the entire statute. The entire statute is supposed to be given effect.
Yes, sir.
But I'm curious because people are making you're suggesting that cash is property.
I am.
Or services, I guess, but it's cash.
Cash,
So
cash.
it's, when is if that's true, then when is a forgery not for property or services?
Yeah. We had the exact same question
Yeah.
at the Court of Appeals, and to be honest with you, I can't answer that. I don't
Well,
know.
I mean, why would the legislature say, that there's the defendant always has the value ladder? I mean, they're essentially, that argument leads ultimately, it seems,
Why is it?
to the conclusion that this offense is never a state jail felony. And I think the legislature said, though, it is in some circumstances, and this is what it's very difficult to try to figure out is how do you give effect to that language that it can be a felony if cash is property or services, is included in that.
Well, I'm not willing to give up on the argument that it could be for something else. I suppose it could be for something else, some sort of influence or something along those lines. I'm not sure how that could work. I'd have to think that through. But to answer your question more directly, it's not in a vacuum because you've got the value amounts too, right? I mean, the value amount's restricted, right? We're only talking about little checks here, right? $750 up to $750, right? The other, if it's over $750, regardless of what it's for, or it's for goods and services, but $751, well, it's going to fall under D.
Well, so what public interest then, let me ask you this, is there a public interest that's served by saying someone who does this, who commits a forgery for something other than property or services is really, really bad?
Yeah.
And someone who does it for property or services, yeah, you know, we just understand. Some humans do bad things sometimes. They steal bread because they're hungry. They might steal a car because they think that it's important to get across town for some reason. And in those circumstances, we don't want to punish them too severely. But if they're doing it for something else other than property or services, what is that else thing? That seems to me the way this statute suggests by its plain language. And I'm wondering, is there some public interest at stake that they're trying to protect here?
Judge, I understand your question. I'm sorry, I don't have an answer for you. I'm sorry, that's the honest truth.
Well, I have a different question.
Yes, sir.
Again, I have to go back to this. I'm looking at the indictment, okay?
Sir.
And it says punished as second-degree felony.
Obje-
Now,
objection.
if this is an E1 misdemeanor indictment, is there any way that these prior felonies can aggravate this or enhance this to a second-degree felony? Not that I'm aware of. Is there one that I'm missing?
No, sir.
So if this is an E1 misdemeanor indictment,
Correct.
that language, punished as a second degree, even if
Yes.
you get past the state jail felony piece, but that language, punished as a second degree, that is a clear indication to defense counsel that the state is moving forward as state jail felonies and that he must make an objection so his client doesn't get hammered with a second degree felony, which is what happened here, is it not?
I agree with the first part of your question, and you had me all the way up.
Then where do you deviate on the second?
It alleges both. If it didn't allege both, if it just went that far, and you didn't include the check amounts, I'd say, you're right, looks like D, no choice, we're stuck under D, gotta raise our hand. But it goes on, and it alleges, it has the check, ergo it alleges D and E1, both.
But on these check amounts, there's no way to get to a felony.
I agree with you.
Okay, so how is it
Factual.
alleging if you're saying the fact that these images of these checks with these amounts are in the indictment alleges both a D felony and an E1 misdemeanor?
Yes, sir.
But if these amounts, under any interpretation of the statute, cannot be a felony, then they cannot be D. How do we get past that?
Well, those facts may or may not end up being true at trial. I mean, you could allege one thing and it's not true or it's not proved at trial.
But what's alleged here is D, a felony, a state jail felony enhanced to punishment as a second-degree felony.
I contend it's both.
Okay.
I contend it's both. I don't know how to, I'm sorry, I'm not trying to be argumentative.
No, that's the point. That's what we're here for.
I completely agree that it does follow, and in a perfect world, should an objection have been made? Yeah, that would have been great. It would have been great. It wasn't. But my contention has to be that just because you allege something doesn't necessarily mean it be proved at trial. It could go to trial, and we know that, that the statute says if it is proven at trial, E1, then it's E1. Well, it might have been D. It might have been D at the trial. Here it wasn't. It was proved to be E1 with the check amounts and the purpose at that time.
I have a question for you. What if you assume it was only D1? Isn't this really a sufficiency question?
I'm sorry, I'm not.
If you assume it's only D1 in the indictment, isn't it really a sufficiency question?
Well, that becomes a little difficult because the state's going to argue it's lesser included, and if you qualify for, if you offer evidence of that, that would be their argument. If you offer evidence of that, well, then you've met D and E1. That would be their argument. My contention, my counter response to that, to go down the road, is that it's not lesser included. Why? Again, the argument, it is subject to or controlled by. So my contention is not lesser included. If to lesser included, then it becomes a little bit more problematic, right?
Right.
I don't know how to answer that any further than that. Having given all that, back on track. We know it's not a estoppel. Cast that out. My argument is it's not a defensive issue. Cast that out. If we've casted that out, what are we left with? We're left with the structure of jury charge error as established by Almanza, which is, was there an error? Was there harm? If it was objected to. Or, if it was objected to, was there an error and was it egregious error?
He was convicted of a felony, aggravated to a second-degree felony, on what would arguably be 3 Class B misdemeanors. How is that not egregious error?
I completely agree, and that's what the Court of Appeals said.
Okay.
I completely agree.
But you said that both apply, D and E. So if both apply, how is there a jury charge error? What would be the jury charge error if you're saying the indictment alleged both?
Yes.
If I'm following your argument correctly.
You're correct, and I agree with that. But again, we're going back to, hey, okay, you've gone down the road. Indictment, D, E1. Evidence, D, E1. Charge, what do we do? Well, we know what we do because the statute says that D is subject to E1. And we know that this court says E1 controls. It's not optional. It's not optional at that point. If the indictment and the evidence show both, and we get to the end and we're at the charge error, or we're at the charge conference, then the court has one choice. The court must submit E1 because it controls. Has no choice. It's not a lesser included. It's not a strategy decision. It's not elective. It's not discretionary. Must be done. It is the law applicable to the case. That's my contention. Which is why, again, circling around, that's why I say it's not a defensive issue.
Well, let me go back to you there.
Yes,
with
sir.
that. It's not a defensive issue because it's subject to, and it's not discretionary.
Yes.
But normally, with respect to a lesser included offense, there's a separate step for the trial court to make about whether it's possible that he could be guilty of the lesser but not
Yes.
the greater. Is it possible that the legislature, by making it subject to, cut off that much of the discretionary nature of the lesser included and still left it obligatory for you to raise it before the trial court in order for the issue to be preserved for purposes of omission from a jury charge?
Is that possible? I don't know. I'm only making the argument with regard to this particular case. And I'm saying in this particular case that proof, that the proof was the 3 checks, 130, 137, 150, and the purpose, cash, that if that's true, if that's objectively true and it's not contested, as it wasn't here, that's objective, in that situation, it's not lesser included because it can't be both. That's my argument. Now, could it be in other situations?
It's a little hard to criticize a trial court for not reconciling itself to a decision that hadn't been handed down yet.
Completely agree.
Okay.
Completely agree with that, Your Honor.
We do have the power under, I believe it's 78F. Well, we'll address that. Maybe I'll address that later. But applying this decision retroactively to this case is what's causing the
I
challenge, right?
completely agree with that, Your Honor, and I think I think one thing we can agree to is that we have all stumbled through this from the beginning.
Welcome.
And it has been a difficult process.
And I appreciate you going through it with us.
More credit to the state, the state was the first one to really fully understand the problem and to bring it our attention, correctly so. And we've been wrestling in that mud since then, and I think it's remarkably difficult. And I completely agree with the retroactive application because that has application with regard to ineffective assistance to counsel or what the judge did. And when we're looking back 6 years, that strikes me as bonkers, just bonkers. But I hadn't intended to address that with regard to.
Let me maybe go in a little different direction, which
Yes,
is,
sir.
because it seems to me you take things and you push them aside, right? And you've taken defensive instruction and put it aside, but there's also, Presiding Judge Schenk mentioned lesser included offenses.
Lesser
And
included.
it seems to me that when it comes to Almanza, right, that we've treated those two categories, defensive instructions and lesser included offense instructions, differently. And the reason we've treated them differently than typical errors in a charge is because we've said that a defendant has a duty to bring those things up, because he can choose to either bring them up or not. It could be a strategic reason why he
agree.
might not want to do that.
I agree with that.
Right? So, is there any, what would be your argument that this is not a lesser included offense, keeping in mind that there are some specific legislative definitions of lesser included offenses under 3709? And so, I mean, a lot of people think of lesser included offenses and they think, well, you just, if it has one less element,
Right.
then it's a lesser included offense.
Right.
But there really are more definitions of lesser included offenses than
Yeah.
that, right?
Agreed.
And so, have you eliminated the possibility that this E1 crime could be a lesser included offense to the one that was actually charged?
Could it be theoretically? Yes, yes. What's my argument that it's not? My only argument can be that the legislature specifically said something special. And it said it is subject to.
Yeah.
That's all I've got.
Why doesn't that mean then that if it's a lesser included offense under that other instruction, then it's not this?
Well, the
It's
Court of
not
Appeals-
D, if it's E, that's what they're saying. If it's E1, it's not D.
Yes.
So
Yes.
doesn't that fit when you're talking about possible lesser included offense? The legislature may be going after, saying that perhaps
Yeah.
there's a public interest in making sure that when somebody is only trying to get property or services, then we don't want to punish them as harshly. So what's the category when they're not trying to get property or services, when they ought to be punished more harshly and not more leniently? Do you see what I'm thinking about here? Or,
Yeah, my
okay.
time is up, so to respond, if I could. Yeah. I think that's got to tie in with the amounts, that those two together come together to make that differentiation, not just the purpose, but the amounts, that those tie together to make it. But to make the point, the Court of Appeals addressed this the first time and said, well, I think here's my conclusions. Boom, 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 boom. This court came back and said, we agree with 1 and 2, we don't agree with the rest, and you addressed it. Well, what was 1 and 2 that you agreed with? I took that from the Court of Appeals to mean, and from this court's opinion, that it controls, and that you were saying something special. I thought, maybe I'm wrong, that you were saying that when those two overlap, that it's not lesser included, there's no question, no discretion, E1 applies. That's what I took it as. I may be wrong, that's what I understood it to be. I'm over my time, I apologize, I appreciate the court's attention.
Thank you very much. We'll now hear rebuttal.
All right, Mr. Shell, I'm going to ambush you before you start.
This is a great way for me to start.
So you mentioned, well, the defendant didn't file a motion to quash, didn't complain pre-trial. Like, what's the defendant supposed to complain about? Like, I'm putting my trial judge hat on, so I'm sitting in docket, and they come up and they say, well, Judge, we have a motion to quash. What's it based on? He's charging me the state charged me under the wrong section.
Yes, sir.
I would look at him like, okay, what do you want me to do about it? Does the indictment allege a complete offense? Well, yeah, but they're charging me under the wrong section. Like, what is the trial judge supposed to do? The trial judge just go, well, I guess we'll see what happens at trial, right?
Well, I think the trial court judge first takes a look at the indictment, and then he or she then hears the arguments of counsel. And
But what would the
Then this-
argument be? But the argument would be necessarily from the defense would be, no, my guy was trying to get goods and services. So he's being charged in the wrong section. And the state would say, I'm sorry, is anyone sitting in the witness stand right now? How do we know that? All I know is I have an indictment with a complete offense. Like, what would you want the trial court to do?
okay, here's how I'm going to address your question. First of all, the indictment comes out from the grand jury. District clerk gives a copy of the indictment to the state, gives a copy of the indictment to the defense attorney. Shortly thereafter, 39.14 Michael Moore Discovery Act, requires the state, upon reasonable request, to then provide discovery to the defense attorney. Defense attorney then takes the time to look at that discovery and determine what the evidence truly is. What does the state truly have in its possession that proves that whatever is alleged to be the forgery, which is a writing, by the way, that's the key to any forgery, the writing. Then the defense is in a position to say, this evidence that you have provided me as defense counsel proves that this is subject to either D, E, or E1. And Judge, this is our argument. Our argument is, based on what we've seen in discovery, this is an offense under E1, and they haven't charged it this way. Therefore, the defense's motion to quash should be granted.
What about your compatriot's argument that it was charged under E1?
Well, I don't think it was. We're going to have to disagree on that. Right? It's a 6-year-old case. We've disagreed before, and it's okay. But if you look at this indictment, to Judge Finley's point, says state jail felony. It doesn't say state jail felony 32.21E1. It doesn't say that. It doesn't say D either. But
Counsel?
this court said in Green, okay, Green was the companion case to Lennox. Green went up, and the difference between Green and Lennox is Green involved a $20 forged bill. That, under E, used to be a third-degree felony. You don't forge our money.
Counsel,
Yes.
I was wondering, can you commit forgery without actually uttering the forged instrument?
You can possess it.
Right.
Yes.
So why is it the conduct engaged to obtain property or services isn't a reference to uttering the document rather than merely possessing it?
Well, I think that becomes then a question of manner and means. Is it uttered? Is it passed?
But that might suggest two different offenses.
It could, but it's still within the global framework of a forgery.
Counsel?
Yes.
Should we give any significance to the fact that this is an indictment and not an information? I understand you can use an indictment for a misdemeanor, but
Sure.
if this is a misdemeanor complete, should we give any significance to the fact that it's an indictment, generally used for felonies, as opposed to an information?
Correct. Well, it's an indictment, but it's not an information. If it was an information under E1, then it wouldn't have been in the 6th District Court
That's
to
my
begin
point
with.
exactly. If this issue is, hey, this is actually a misdemeanor, not a felony,
Yes,
that
sir.
would deprive this court of jurisdiction.
Yes,
Is that not something counsel would be expected to bring up before you went to trial?
absolutely it
Should we
would
give
have
any
been.
significance to that?
It absolutely has significance, and that's part of my point here. Part of my point is that, look, this was alleged as a state jail felony. He contends it's a misdemeanor. If it's a misdemeanor, then you object, you move to quash, and it goes to a county court at law in Lamar County. But that's not what happened here. That's my whole point. There was no motion to quash this indictment.
So is there any significance to defense counsel proceeding in the district court where he would know it would have to rise to the level of a felony to be? Is there any significance to that or no?
He would have to go forward in the district court, and then at some point in time, bring up, as the evidence developed during the trial, that E1 is in play. And then E1 requires this to be done in a different manner. But for purposes of this, and this is where the state's asking for very specific relief, to avoid going retroactively back. Affirm the trial court's conviction, clarify what E1 means. Is it a lesser, is it a defensive issue? What is it? Don't use this case as a test case. Affirm what the trial court did. Say that this was never preserved under Marin.
Couldn't we have done that the first time? But we didn't, right? The reason I ask, I've asked this question earlier, still used to the Court of Appeals companion to what is Rule 78 for us. But that has should. Ours do not have should. We basically can enter any order under Rule 78 that we think is necessary to get the case justly and efficiently decided.
Yes, sir.
We're a little late in this one, but there should not be a third proceeding in the Court of Appeals. Would you agree with that?
I agree. That's why this is a de novo review, and that's why we framed it as a de novo review, so that this court could make a final call. We're asking this court to make the final call and affirm the trial court's final judgment of conviction and reverse the judgment and opinion of the Court of Appeals. I see that I am way over my time.
Well, thank you. Thank you both.
Thank you.